Please be seated. Next case on the calendar is Seatech Marine versus Terra Environmental. We have allotted 15 minutes for the side for this case. We'll hear from counsel for the appellant.
Good morning, Your Honors. Alberta Adams on behalf of First National Insurance Company. We have two appellants, and it's my understanding that we have to split our time, so I will be leaving part of the time for Mr. Walton, who will be addressing change order number 1 for the sand and the prejudgment interest issue. I will be addressing change order number 2, which was for delay damages. Just briefly, this appeal raises the critical question on my part of the argument of whether a statutory payment bond issued pursuant to Section 255.05 covers a subcontractor's claim for delay damages as a matter of law. This is a purely legal question for Your Honors because everyone admits that change order number 2 was purely for delay damages and nothing else. Briefly, the background, the appeal arises out of a dredging project for the Jacksonville Port Authority. They're basically taking contaminated soils out of the harbor. Seatech was the general contractor on this public project and had to post a bond. My client, First National, provided that bond, which is indisputably a statutory bond required by 255.05. As is common in the construction industry, Seatech subcontracted portions of the work. One of the subcontractors was the appellee Terra. Terra's job was to do what we call the land portion of the job, which is to take the dredged material once it's pulled out of the harbor by Seatech and mix it and stabilize it with a variety of stabilizing agents at Seatech's choosing, and Mr. Walton will talk about that. During the course of the project, some delays allegedly arose, and Terra presented a change order for delay damages. The trial court awarded Terra delay damages against the bond in direct contravention of 255.05.
You say direct contravention.
Yes, sir.
But the statute talks about labor, service, and materials, right?
That is correct. It does not talk about delays. It talks about things.
Well, what are delay damages based on?
Delay damages are based on having a job taking longer than what you thought it was going to take.
Isn't that an aspect of labor?
No, sir, and not in terms of the statute. That is a consequential damage. It is not a direct labor cost. It is a consequential damage as a result of you being out there longer. And Terra here had a lump sum contract.
I understand that.
So they agreed to do this. It wasn't a time and materials. Mm-hmm. If had it been time and materials, then yes, they would have been compensated for their time and materials. They, in fact, insisted on having lump sum. And there are only 2 cases in the state of Florida that have addressed this issue. In both of them, the Stratton case and the DIC case, both of them have held that delay damages are not covered under 255.05 statutory payment bond because the statute does not specifically provide for delay damages. It does not specifically provide for consequential damages. There is no case in the state of Florida awarding a subcontractor delay damages under a payment bond. There are a few cases that Terra. I'm sorry, Your Honor.
Let me ask you a question about 255.05.
Yes, sir.
Does 255.05(1)A not state that the claimant shall have a right of action against the contractor and surety for the amount due him or her under the claimant's contract?
For labor, materials, and services.
Does it say for labor, materials, and services?
Yes, sir. Shall be conditioned. Such bond shall be conditioned upon the contractor's performance of the construction work in the time and manner prescribed in the contract and promptly making payments to all persons defined in Section 713.01 who furnish labor, services, or materials for the prosecution of the work provided for in the contract.
Does it not also say the claimant shall have a right of action against the contractor and surety for the amount due him or her under the claimant's contract.
Yes, sir. And in this
And
contract...
what you've just read, all that does is really define material men and subcontractors, doesn't it? I mean, isn't that one way to read it? Because it talks about persons defined in 71301 who furnish labor, services, or materials, and that defines subcontractors and material men, doesn't it?
It defines, I believe, the condition of the bond. It says such
Well, that's one way to read
bond
it.
shall be conditioned upon providing labor, services, or material.
But if it's limited to that, then why is the language in the same subsection that provides that the claimant, who is, I guess, the subcontractor or the material man, shall have a right of action against the contractor and surety for the amount due under the contract?
And that is modified by the surety, the condition of the surety's bond, which is to furnish labor, services, or materials for prosecution of the work. And even if you take your honors rating of 255.05, which isn't the reading that was adopted by the other courts that have addressed this issue, but if you take your honors rating, this contract contained a no damage for delay clause.
Counsel, does Section 255.05 use the phrase delay damages anywhere in the section?
No, sir. Nowhere in 255.05 does it provide coverage for delay damages. Nowhere does it address delay damages, and in fact, that's something that was pointed out by the courts in Stratton and DCC. Getting back to 250.
You said the contract had a no damages for delay.
Yes, sir.
That's the prime contract, isn't it?
Correct, but that was incorporated.
The subcontract did it not?
No, it did not. The subcontract incorporated the prime contract, which contained a no damage for delay clause. It expressly incorporated it. And that was at the subcontract, and that was Section 11 of the general conditions of the prime contract, which was expressly incorporated into the subcontract.
Counsel, if we agree with the trial court that the 2004 version of Section 255.05 applies, then how does that affect your case?
It does not, Your Honor. Plaza Materials, a Florida Supreme Court directly addressed that issue. The Florida Supreme Court addressed the 1980 version, which was the version in effect in 2004, of 255.05, and under that version, it said that it was a statutory bond. And the Florida Supreme Court looked at that and said, yes, it is a statutory bond. The reason for the change in 2005 is while Plaza Materials was pending before the Florida Supreme Court, the legislature got nervous that the Florida Supreme Court might do the wrong thing. And I've cited to you the legislative history of that amendment in 2005, and it says, for future public construction bonds, these amendments should eliminate an issue currently being considered by the Florida Supreme Court, and then the legislature cites to Plaza Materials, which was pending, which is whether the failure of a public construction bond to specifically refer to statutory notice and time limitations converts that bond into a common law bond.
Then are you arguing that the legislature intended to limit a surety's ability to provide more coverage than Section 255.05?
That is correct. What they wanted was certainty, not just to limit a surety's ability. They wanted certainty. What was happening is courts were running around, and if there was one little word in the bond that wasn't exactly like 255.05, they were saying it was a common law bond. And applying...
But in Plaza Materials, I found interesting that they seemed to look to the spirit of the statute, and they gave a pretty broad interpretation in finding that a subcontractor in that case could litigate a claim, even though, as Justice Cantero argued quite vigorously in his dissenting opinion, even though this contractor had not met any of the time deadlines. So under that type of approach to the statute, should we look at it broadly as well in terms of delay damages?
No, sir. What the court said is that we are going to deem it a statutory bond. We are going to do what the legislature said back in 1980, which is the version of...
And then they proceeded to say that the time limitations applicable to subcontractors, in fact, all three of them, including the one-year statute of limitations or the tolling provision, didn't apply.
No, what they said, they didn't say they didn't apply.
Well, they said they didn't apply if subsection 6 is not complied with.
Yes. What the court said...
So they applied an equitable gloss to the statute.
What they said is that it's a statutory bond, and we're going to view it as a statutory bond, and we're going to give effect to subsection 4, which says it's a statutory bond. But if the bond does not contain the notice and time limitations, which aren't at issue here, but if it doesn't contain the notice and time limitations of subsection 6, then we are going to allow the subcontractor to argue that the surety is stopped from arguing those notice and time limitations because the subcontractor wasn't given notice in the bond.
The surety ought to be stopped here because the surety failed to insist that the prime contractor inform the subcontractors that no delay damages would be permitted?
There's no requirement of that under the statute. 255.056 says the bond shall include the notice and time limitations. That was the basis for the estoppel. There's nothing in 255.05 that says that the surety shall notify the subcontractor that there are no damages for delay. And here, it was a contract provision that there were no damages for delay. I'm going to reserve the rest of my time for Mr. Walton unless Your Honors have any other questions, but we would ask that you find that the delay damages are not covered under the bond. Thank you.
You have 5 minutes remaining.
If it pleases the Court, Your Honor. I'm Howard Walton. I'm here to speak on behalf of CTEC, co-appellant. Your Honor, I'm going to address a second item of damages which was awarded to the appellee in this case. This would be $118,576, which the appellee referred to as their quote-unquote change order number 1. The thing that I think is important to bear in mind when looking at this particular issue is that at Section E3 of the subcontract agreement with respect to any extra work, and that's what was sought here, additional money for additional sand that they claimed they needed to use on the project, there was a pay-when-paid provision in place. And what that meant, as Your Honors probably know, is that if the owner does not pay my client, then the appellee does not get paid. Now, where I think there was error committed in this case is that this was a government job. The Port Authority was the project owner, and their man testified at trial, his name was Randy Murray, that he never approved this $118,576 request that was given by the appellee to my client and forwarded to the Port Authority. He made it clear, no, they chose to use sand. They had several different agents they could have used. The fact that the sand wasn't absorbed.
The court made a determination regarding Mr. Murray's credibility, didn't it?
Your Honor, I think that the issue is that while they may have been able to weigh Mr. Murray's credibility, the simple fact of the matter is he was not at all inconsistent. And in fact, his testimony was supported by a worksheet which he filled out. And he discussed what the contents of that worksheet were and how they reflected what this payment of $344,000 from the Port Authority to my client, which is really what we're fighting about here and actually includes the items also that Ms. Adams has argued about, was composed of. And he said that $118,576 was not in there. Now, in Appellee's brief, he stated that Mr. Murray was initially inconsistent when he testified. But if you go back and review the record, Your Honors, you'll see he was not inconsistent. When he testified, the portion of the record which Appellee cited to was discussing this change order in general and saying that there was compensable delay money that was paid at that made up the $344,000 change order. When on cross-examination he was asked by myself and Ms. Adams specifically about this $118,576, he made it abundantly clear, I never approved that.
Your best argument is this is a lump sum contract, right?
That is indeed.
I mean, your opponent agreed to $1.02 million, the set price. That company didn't require your company to pay by the truckload, correct?
That is correct, Your Honor. You're absolutely right. He said a lump sum price.
In fact, that company, Terra, refused a contract to be determined by the truckload or by the amount, correct?
Correct, sir. And that, I think, buoys the conclusion that there was no competent evidence when we look at the pay-when-pay provision, the fact that this was a lump sum. My client could have held him to it. This can't be some subsequent modification between the parties or separate contract because there's no consideration.
But your client did submit this amount, the $118,000, as a change order to JP for reimbursement, right?
Yes, Your Honor. And under E1 of the contract, it makes it clear for changes in the work that the owner may make changes. Now, on a public project like this, my client, the general contractor, can't simply decide on their own to change the scope of the contract. They've got to get the okay of the governmental authority, the Port Authority.
But if we agree with the trial court that CTEC and JPA approved the change order, granting HydroTerra the $118,576.50 for additional sand, isn't the question of how much additional sand HydroTerra actually used irrelevant for purposes of this case?
Your Honor, I think that that also goes to the evidence, the fact that we had a surveyor who testified that the exact amount was not used. But, Your Honor, the strongest point of the argument here is that 118,576 was not approved by the Port Authority, and their witness, Randy Murray, made that abundantly clear. Your Honors, I see I'm down to a very little time. I would ask for an extension of 1 minute for Ms. Adams to present rebuttal argument.
We'll give you a minute total for rebuttal, and you all can decide how you want to use it.
Thank you, Your Honor.
Mr. Smith?
Your Honors, I'm Holt Smith. I represent the appellee, HydroTerra Environmental Services. 2 parts, delay damages. Second part is the sand. First of all, the subcontract included the prime contract. The prime contract included all change orders.
Counsel, regarding the sand.
Yes, sir.
Is there any correspondence between CTEC and JPA that specifically quotes the $118,000 figure?
Specifically, no. There isn't. However, there is Mr. Murray's testimony. Mr. Murray stated that there is evidence in there that the request for additional sand and solidification and stabilization work was submitted to JPA. JPA did, in fact, grant that and authorize the payment and did pay. That's another thing about this whole case. There was payment for delayed damages as conclusively testified to by Mr. Murray. Mr. Murray also testified on direct examination that the JPA did pay for the additional sand and the additional solidification and stabilization. And Judge Thomas, one of the issues that you brought out was what do we have as far as the additional sand and what was being done here? Why was there delayed damages? If you look at the change orders that were submitted by HydroTerra to CTEC, those change orders show that the change order was made up by the request for additional labor and additional equipment that was on site. There was testimony given that the equipment could not be taken off site. There was 3 back-to-back hurricanes. They had to leave the equipment on site thinking that when one hurricane was over, they didn't expect more hurricanes to come.
That's my question.
Yes, sir.
Regarding, I mean, your opposing counsel has on its face an argument based on the text of the statute that delayed damages are not included. Now, labor, service, and materials, and aside from the contractual language that Judge Webster mentioned, but labor, service, and materials on its face does not seem to include as a term of art delayed damages. But when I look at plaza materials, we could look at the statute and say, well, the concept could include delayed damages under certain circumstances, and you could elaborate on that.
I think it's important for the court to go back and look at the Plaza Materials case. Plaza was a 255-04 versus 255-06 conundrum. The Supreme Court decided how they were going to take 2 apparently inconsistent positions, in the statute and meld them together so it'd be a workable solution without saying one trumped the other, one section trumped the other.
They said the time limits didn't apply.
Exactly.
So can you tell us how that would analogize to looking at labor, service, and materials and whether delayed damages is included?
In this particular situation, I think all the cases that we have cited in our brief, that would include American Home versus Plaza, the Florida Crushed Stone, Martin Paving, the WSA Stratton case, the DIC Travelers, the case of Federal Insurance, Larkin and Gulf, Florida. All of those cases speak to the fact that a surety can contract to matters that are greater than the minimum requirements of the statute. If we are looking at requirements of the statute, we would be looking at minimum requirements. Plaza cites Florida Crushed Stone. Florida Crushed Stone was a 5th ECA case. The 5th ECA said the same thing that was adopted by the Supreme Court, and that is you take the subsection 4 and subsection 6, you see if there was prejudice, they would have to be approving of prejudice by the claimant. that the claimant was unable to perfect its notice requirements because the information wasn't in the bond. Florida Crushed Stone, interestingly, footnote 3 of the decision cites to Martin Paving, and cites to Martin Paving, and in this case it says that, in the Martin Paving case, says but as we have read Section 255, this is the Florida Crushed Stone, perhaps the most unambiguous portion of the statute, however, no longer recognizes a common law payment bond given on a public works project. Then it cites footnote 3. And then it says, although we held in Martin Paving that there remains a common law bond for those protections which exceed the minimum obligations imposed by statute, we're not talking about that in this particular case. That wasn't an issue. Martin Paving is even more specific. It was decided by the 5th District right after the change in the statute that brought in the issue of whether the payment bond can be, is a statutory payment bond. And they said, we begin by rejecting United's principal contention that enactment of subsection 4 of 255.05 made a dinosaur of the concept of a common law bond. Nothing in this language can support the conclusion that common law bonds have ceased to exist in Florida. And I'll be honest with the court, it's a little bit confusing if you look at all these decisions what a common law bond is. I've stated here I don't believe we had a conversion in the sense of what a common law bond conversion was in most of the cases involving a common law conversion. It's when you had a failure of the bonding company in the surety in his bond to give the proper information to the prejudice of, or in some cases not to the prejudice of, the party who was seeking the claim. The courts in those days said, well, you didn't give the proper information here, ergo, we're going to strike the restrictions in the bond as to the time limits, as to the notifications. Therefore, they came up with the term common law bond. This, I think, is a little bit further up the ladder than just a plain common law bond.
Counsel, wasn't First National entitled to rely on the representation in the prime contract that no delay damages would be awarded?
Well, actually, Your Honor, if you read the contract carefully, you'll find out it doesn't say that. What it says in there specifically with respect to the facts of this case, if you have normally expected weather, you get time considerations only. But it doesn't say anything about abnormally expected. In this particular situation, we had back-to-back hurricanes over a 6-week period. 3 hurricanes from the middle of August until the end of September. Those 3 hurricanes, according to Mr. Randy Murray, who was the JPA representative, were extraordinary circumstances. Leapfrogging the terms, or tying into the terms of the contract, the JPA submitted a submission to the executive director, and as grounds for actually giving the delay damages and the increased cost of construction, it said we've had extraordinary weather conditions, which in fact is
Nobody's arguing that.
Nobody's arguing that. 3 hurricanes wiped the whole project out, 3 on 3 consecutive occasions. The JPA looked at that. The executive director said, fine, even if we had a contract that said that, we're now going to approve and pay this change order for delay damages and for additional sand. And I would also point out, Your Honors, that with respect to what that payment was for, it's uncontested that all of the money that was paid in change order 4 was with respect to the subcontractor Terra's problems that they had on the project site, because CTEC had already demobilized from the project and wasn't on the project. They had no impact on their part. They were not submitting a request for change order for delay damages and additional sand and stabilization work on their behalf. They were submitting it on behalf.
How did Terra demand payment under the change orders before March 2nd of 2005?
Yes, sir. They did not on October of 04. Yes, sir. That matter of fact, the sequence of events was that the Terra people, as the hurricanes began, they submitted a letter to CTEC and said, we've got hurricanes, we're shut down, we've got our equipment on the site, we need to be compensated.
So what rule should, if this court were to write an opinion in this case for this district, regarding the interpretation of these provisions. You have the provisions regarding labor, service, and materials, and you have the provisions that Judge Webster mentioned previously regarding payment for the contract. The claimant shall have a right of action
Right.
for the amount due him or her, including unpaid finance charges due under the contract.
In
Do
this
we say that delay damages are always in play?
No, I don't think you would. What I would say, Your Honor, is that if you look at the contract, in this particular case, the contract is the matter between the parties. And this particular contract incorporates the prime contract and all change orders.
Well, I think what Judge Thomas is asking you is, do we say that delay damages are always in play under this section if they're provided for in the subcontract?
Absolutely. Yes, sir. I think that if you look at the decision in Larkin, you find where the Larkin court said, we hold that a surety cannot be held liable for delay damages due to the contractor's default unless the bond specifically provides coverage for delay damages. In this particular case, with respect to the delay damages, you have to go back to the contract, which is included in the bond and the change orders.
Well, it's clear the prime contract expressly says there is no right to delay damages. The subcontract, however, between your client and CTEC says that any claim for delay damages and some other damages is contingent upon CTEC receiving payment from the owner.
Right. And they got paid.
So how would the surety company, I guess they'd have to look at all the subcontracts to find out what their undertaking was in every case?
Well, Your Honor, I guess they could enter into a contract that protected them.
But the whole point of the surety relationship is they're protecting the general contractor.
Well, they're actually twofold. One is they protect the owner, which is JPA, the city or the state or whoever. And second is they're protecting the subcontractors. That's the purpose behind the bond. It's not to protect the contractor. It's to indemnify.
But I guess what I'm asking you is isn't it true that if your take on this is right, that in order to determine its scope of potential exposure, a surety in every case would have to look at every subcontract? How else would the surety here have known about the possibility of delay damages being an issue?
The surety would have known about it because they issued a surety bond that included the contract and all change orders. But they would have determined by that.
Is it change order 4? What's the change order?
Change order number 4.
Okay. Does it expressly say it includes delay damages?
Yes, sir.
Okay.
If you look at the change order 4 and you look at the testimony of Randy Murray, Randy Murray was the executive director. I mean, he was the port engineer who submitted the change order to the port. He specifically stated in there that this particular change order is for both delay damages and for additional sand and solidification work. He was mentioned by Mr. Howard over here.
But we wouldn't expect the surety to know when it enters into this agreement what Mr. Murray's going to testify.
No.
So you say by looking at change order number 4, they could have determined that the delay damages might be in play here.
Well, they couldn't do that in advance, obviously.
No, they couldn't.
No, they could not. Absolutely could not.
And I think your opposing counsel mentioned what the legislature wants here in this statute is certainty. Certainty for the sureties, certainty for the public entities. And isn't that a concern that a surety issues a bond and the contractor makes reckless subcontract agreements and knows that, hey, the surety's on the hook?
Well, actually, if you go back and look at the Plaza case and look at the legislative history behind this, you'll find out where the initial intention was to establish a bond of a specific consideration as far as how it was going to be structured. What happened was the sureties came up and said, no, we don't want that certainty. So if you look at 255.053, it says this is a permissive form of bond, which is somewhat inconsistent within the statute as far as what counsel over here is talking about, and that is that you have one type of bond for one type of recovery. That's not what it says. This is a permissive payment and performance bond.
Mr. Smith, what troubles me about your position on the bond issue is I don't see, if you're right, how a surety, when it's entering into negotiations with a general contractor, could ever know, number one, what its actual potential risk is, and number two, thereby how much to charge for the bond.
Your Honor, it's like every other contract you enter into. You will make certain assumptions as you're entering into this contract. You establish your bond based upon what you think may happen.
But wouldn't the assumption here, given the prime contract, be that there are no delay damages?
Let me reiterate on the prime contract. That prime contract, the provision in the prime contract that talks about delays, compensatory delays, it does say in particularity you have delays that are compensable if you have extraordinary weather conditions. It's specifically in that contract. It does not exclude the recovery of compensation for that, and it was compensated. Thank you.
Thank you.
If I could quickly, Your Honors, I would like to hit on a few things. The Supreme Court and Plaza Materials expressly noted that the statute was designed to protect the surety as well. It specifically says the statute at issue was also designed to afford protection to both the surety on the project and the public. So that was part of the reason for the legislature in 1980 making these statutory bonds. And then in 2005, when it was afraid, not knowing what was going to happen in Plaza Materials, expressly stating what the statute already held, which is that it can't be a common law bond. It must be a statutory bond. I think that's just so clear from the statute. With regard to the question of delay damages being covered under the statute, the fact that we keep calling them delay damages shows they're not covered under the statute. We're talking about damages, about consequential items, not about an item of work that was provided for under the contract and there's a contract amount for that. It is a damage. If Your Honors say today that delay damages are covered under a 255.05 bond, you might as well say broken equipment would be covered under the bond. A personal injury claim would be covered under the bond. Any type of damage claim that a subcontractor could come up with would be covered under the bond, and that's not what 255.05 was designed to protect. It's not what it says. What it says is you get paid for your labor and material. Thank you.
Over your time.
Thank you.
Thank you both. Thank you all, actually.